यहाँ से ये चले
Madam, I'm for the state in for the circuit bench matter, madam.
You are appearing on whoever whom?
Madam, for Malad is taking circuit bench matter.
Yes.
Madam, I'm for the state, madam.
Who is for the writ petition then? I have not heard her. A
Madam,
lady.
writ petitioner is not appearing, madam. Since last Thursday, no one is appearing for the petitioner, madam.
यहाँ से यहाँ से one lady advocate was there, no?
Initially, Mr. Devosridhar appeared, but he says that he has retired from the brief,
No.
from the case.
His name is appearing on the screen. Very good. Yes, Mr. Mujumdar.
Lord, I will take only 5 minutes of your lordship's time.
Yes, sir.
Not the
Madam, my name may be recorded for the state, madam.
Give you a slip.
The chat box is disabled.
এই ওটা দিয়ে দাও নামগুলো নিয়ে নিও কে আছেন এটা নিয়ে নাও উকিল বাবুর নাম এটাতে ওই স্টেট অ্যাডভোকেটের লয়ার নাম নিয়ে নাও Yes, Mr. Mujumdar.
Counter the argument that the writ applications were filed after
You
the
stopped yesterday that no review of judgment of division bench is permissible in this writ petition. There you stopped.
only 3 points I formulate. First argument was writ applications were filed after the process was finalized or after the examination was held and the list was prepared. The WPA 21918 of 2024 was filed before that. So the writ petition
How after holding written examination?
before the 2024 examination.
WPA number
21918 of 2024.
Yes.
That so far as the opposition and reply are concerned, not the stand of the commission is concerned before the honorable division bench, I have indicated yesterday. Pages 148 to 151 of the opposition, and at page 156 of the opposition. Second note, the observation failed from your lordship as to the, I should address your lordship on the point of ratio decidendi, their submission. But what is the ratio? But it has a precedential value in so far as settling a question of law. Not the all judgments cited at the bar on the principle of ratio decidendi will have no manner of application in this case because it's a question of an order binding the commission. There may be a direction without a ratio. Say for example, there may be a direction without a ratio. Inter se the parties, the order is binding. Commission cannot take now the stand that very well, it has not decided a question of law, therefore I will not be governed by that order. This will lead to judicial anarchy.
Yes.
My lord, in the preliminary examination held in 2010, there were 3 sessions, same question paper with orientation differently laid, as it happens in every other examination nowadays. The question said, the orientation of the questions will be changed in every session. Same set of 100 questions will be there, but say 1 to 30, what is 1 to 30 in first session, maybe 10 to 20 in the second
No,
session.
no, they said that it was on three different set of papers.
Different set of papers. Maybe, but that does not change the situation.
Be there as it may, we are not on that.
But so far as the judgments are concerned, I have indicated, I have prepared a note, if your lordship accepts, how the judgments are distinguishable. Instead of reading every judgment, this may curtail your lordship's time. Just 1 or 2 sentences. Now, this is in the form of list of dates. The second page goes on to indicate the page numbers in the affidavit in opposition vis-a-vis the stand taken by the commission before the Honorable Division Bench. The third page is the observation of the Honorable Division Bench. Fourth is my submission, whatever I have submitted before your lordship as to why this will not be deviated from and what will be the effect of such deviation. And fifth note is dealing with the case clause. It had to be in my lord. These are my
এটা লিখে রাখুন, উপরে লিখে রাখুন এখানে মিস্টার এস সৌম্য মজুমদার WPA 2198 what online এটা সারা জীবনের জন্য প্রিজার্ভ করে নেই, সেই জন্য মিস্টার ভট্টাচার্য ওটা লিখে রাখুন মিস্টার সৌম্য মজুমদার আর WPA 21918 of 2024, WPA 24588 আর 25438. Total 11 matters or 12 matters, including Jalpaiguri matters?
12 matters.
হ্যাঁ, ওটা তো ট্যাগড হয়েছে তো। হ্যাঁ। আমাকে দিস
একদম নিচে স্ট্যান্ড থাকা উচিত, তোমার স্ট্যান্ড মানে আমার স্ট্যান্ড মানে হাসি দিয়েছ আমি হাসি
ROOP or RUP?
আর ডাবল
Can't be without an emphasis.
No emphasis. Sir, Mr. Bhattacharya, you are appearing in WPA kindly now.
and I am appearing
The
for
one should be Dirghu in Bengali.
WPA,
I am Jayanta Sardar
kindly tell me the numbers
26090 26090
of 2024.
মাইল আমার তো ওইটাই
Yes, sir.
Yeah, I will also leave.
Yes, sir.
my only short submission to your lordship in reply. Whatever I have gathered from the notes not furnished to me, the submissions furnished, the answer is not there as to what prompted them to initiate a fresh process by way of the fresh selection or written test. The endeavor to conduct written test, why it was done is not explained. I do not propose to multiply anything to whatever Mr. Majumdar has submitted. I only hasten to add that they understood the purport of the order in their own way. That would find reflection from the documents appended to the writ petition itself. Which documents, Milord? Page 49. Page 50.
Comprehensive affidavit.
In the writ petition. These are referred to in the writ petition.
Your read petition.
Yes. Page 26090.
Page number
49.
then
Then, my lord, is page 50.
what have you got to say?
Now, my lord, in these two documents, up to page 53, the answer is very clear that in terms of the division bench's judgment, no written examination, nothing. Whatever was there, we will complete the process. The language used need not trouble your lordship, my lord. Language used in the document is has planned to complete the recruitment process in terms of the division bench's order. So if that was the understanding, then nothing
Very good. I understand your content, sir.
nothing prompted them to issue page 55, dated
Yes.
5th August 2024. Now, my lord, as my learned senior, my lord, Mr. Mujumdar pointed out, ratio, my lord, subject to correction, the ratio of a judgment is, my lord, whatever he has explained in addition, just, my lord, only one sentence. What can be logically deduced therefrom from the reading of the judgment? The reading of the judgment, the teeth of the judgment, very clearly says that one is debarred in law from filing an application. Paragraph 17, your lordship has read it innumerable times. The endeavor to hold afresh, we would have proceeded to reject the same, but consider the plight of who have participated, their fate, we feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. We are unable to comprehend the stand of the applicant. The further written test is required. That was expressly rejected, not implied. It is not an implied observation or implied conclusion. If a point which is raised, if an issue which is raised is expressly rejected, the authorities are debarred in law to proceed in a manner which is in complete deviation to the conclusion reached by the Honorable Division Bench.
Very good, sir. I understand.
So, my lord, therefore, the ratio is here, no written test, complete the process as affirmed by the division bench. This is where, in an application, this is the 20th application taken out by them. Can 20, not can 1. Extension, 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 ultimately can 20.
No.
Whatever.
Yeah.
Very well. Very well. This is on in can 20.
Unsuccessful candidate can.
Now,
Scoreboard does not say the correct figure sometimes.
now, my lord, please see.
20 does not implicate the 20 applications.
Very well. It was numbered as can 20.
Yeah.
Very well. 3 applications. Well, I take it, my lord, I was wrong. But the fact remains, in can 20, there was a previous can 19.
Sir, I don't
So therefore, my lord, I don't repeat.
I
I
understand your
only-
contention that when the division bench, while disposing can 20 as well as similar type of earlier interlocutory application, have debarred the commission from holding any further examination, the only ratio or can be the only ratio rather only conclusion drawn from the said orders that the ratio that the but by no stage of imagination the commission can hold any second examination.
Well, just only one additional sentence. In their entire submission, there is an attempt to, if I may use this word with caution, to hoodwink this court by suggesting that whatever they have done is correct in the light of this simple fact, you know, they have not been
Mr.
able
Bhattacharya, don't enter into the facts, sir. I have,
not
here it has been
This one.
placed.
In their submission, they have not been able to, you know, justify as to what prompted them.
Very-
According to
I understand.
those
Now
are
come to the
matters I
next.
do not want to supplement.
I understand.
whatever
Come to the next point,
distinction-
Mr. Bhattacharya.
Whatever distinction insofar as the judgment cited at the bar, you know, I don't propose to deal with them because, you know, what we learned when we were deviling in the chambers of my learned senior, Milord, that one single difference on facts makes a world of difference between two conclusions reached in a judgment. Milord, the proposition is a single difference on facts makes a world of difference between two conclusions, and judgments cannot be read as Euclid's theorems. Milord, those two propositions are well settled. They need not be, Milord, cited at the bar. Milord, it flows from Quinn versus Lytham, Milord, the English judgment. From there, Milord, this principle emanates, and Milord, it has been accepted by the Indian judiciary to the extent that a single difference on facts makes a world of difference between two conclusions. Number one. Number two, Milord, a judgment, this judgment, a submission has been made that judgments cannot be read in that fashion. It is not, Milord, then if I could have understood that this point was never raised at the bar, it was never raised in an application. When a point is raised and is rejected, the point is refused. And therefore, by no stretch of imagination,
So it has set as rest. I understand.
those are, well, I do not want to multiply.
Anything more? Thank you. Any other?
Well, I am not, unlike Mr. Chatterjee, who will go on for 3 days on this. ভাই, তারপর আপনি চলুন ওখানে, আপনি তো আমাকে ওখানে দেবেন, এখানে কি? চলুন। Mr. Vikas Ranjan, he is our leader. Maybe he is my other side.
Mr. Samim will argue.
Yes. I not argued the question.
Mr. Firdaus Samim. Will conclude.
If my senior
No.
says I can.
No. Mr. Bhattacharya will not get the chance of reply. You have to reply.
Let him contradict himself.
What I learned from my guru, I want to use it against my guru.
You are in WPA
In WPA 26237.
26
237 of
3
2024.
7 of 2024.
Yes, my lord. My lord, Vasudev Bej. My lord,
Your name of your spelling is Firdous.
SAMIM. Firdaus Shamim.
SAMIM.
My lord, I formulate my point because of that, my lord, which fallen from the court which was argued by learned senior, my lord. I deal with wants to deal with which fallen from the court. That is why Madrasa Service Commission not preferred the review. That was the question. I believe no one gave the answer. So I want to give the answer it first. Why they not file the review before the division? They scrutinize the matter. They feel so. That would be a bad decision. That's why they're not filed.
Sorry?
That would be a bad decision to file a review before the division bench. That's why they not filed it. Why I say so? It seems to that a new evidence might be came because of that a new fact 74,000 left out candidate is there. It seems to be a new fact, but that was not the new fact for the Madrasa Service Commission before the division bench, because in Can 20 they expressly says in para 3. I want to read just that paragraph, nothing more, nothing less, my lord. That is which is annexed with
And 20,
Yes, time and again
it was
it is-
there.
yes. Can 20 page number 152. It starts from page number 152 and specific paragraph para 3. I just read the 5 line, my lord, because that was the new fact.
It is Can 20 of 2000.
Can 20 of 2024 in mat number 907 of 28.
Para
3. May I read, my lord? The appellant state that on 12 September 2023, during the pendency of such application, the had already taken a policy decision of to conduct fresh written examination of a total of 1,01,064 candidates. That is 74,618 eligible candidates, which were left out along with 26,444 candidates who had already appeared in the written
Is
examination of
the Honorable
48
Division Bench unable to comprehend?
Yes, Malad, that was the fact in Can 20. On the basis of that fact, the order passed by the division bench on 13 June, Malad. I want to read on 12 September order and 13 June order. And in the interregnum period, Supreme Court order, which my learned friend, learned senior, Malad, time,
Bhattacharya ji.
yes, Mr. Bhattacharya, time and again says, Malad, that's the very important thing. That is very important thing. I want to read 12 September order, Malad. That is the main order, because Can 20, that doesn't mean there are 20 time extension. No. In MAT 807, there are several addition of party application. Factually in the year 2018, my lord, the first time court ordered that publish the marks
Result.
result. That was the first order. In the meanwhile, they not complied it. They preferred an appeal for extension of time.
Sir, I got
Why? Because that fact is
Come to the
important.
point, sir.
The fact is very important. In the meanwhile, COVID came. They prayed again on the score of COVID. They want an extension of time. And in the Can 20, after disposal of the appeal, they prepared an application on the score of that. The new fact came out first time in Can 20 after 12 September order.
Which
So
is the basis of the whole
Yes.
second written
So it is not a matter of obiter dicta. It was a fact. On the basis of that fact, division bench passed the order. So that is the reason they not prepared the review application. That's the reason. And very reasonably, they not prepared the review. Now, my lord, the very next point is, sorry.
Yes.
Now, my lord, I came to the argument preferred by which is argued by the Madrasa Service Commission, being a model selector. He wants to be a model selector, no doubt about it. They says they have error or mistake, and that mistake is a bona fide mistake. They have to prove it bona fide mistake. Now, my lord, I want to interpret in mathematical. 26,000 candidate was assessed. This says left out candidate is 74,000, almost 75,000. So 3 times. So if I represent it mathematically, that means 300% error is there. If I represent it mathematically, they want to remediate it by another mistake. Well, is it tenable in the eye of law?
Yes.
Third point, which came in my lord this court mind, that standard and the normalization. This says we follow and we want to give some remedy to the left out candidate being a model selector by arranging another written examination.
Yes,
No,
I will not allow you to enter.
I am not argued, my lord. I just said the law point, which on the basis of which fact I will not, my lord, argued in the factual aspect. I just what my lord's mind came, that's the reason. So they says we maintain the same standard, which is very, very evasive word, but it's have a huge implication. Why? Because of that, my lord, it might be, it seems to quote there's the same standard. I just put an example. I just wants to give an example. Suppose, my lord, in a examination, suppose there are 2 examination held. In one examination, it is the question was there, what is the capital city of India. Everyone knows New Delhi. In another sets of paper, it was said, what is the capital city of Ghana? May I say that these two are the same standard? If that question is what is the capital city of Bangladesh, that is same.
It is not so.
It
is not so, Mr. Sami.
Malat, in this score, the Supreme Court verdict is very specific. Malat, I don't want to cite but the Supreme Court, what is the settled position of law? Judges are the expert of expert, but judge is not the expert. And Supreme Court time and again says, I don't want to mention that, don't want to cite it. The fact is that Supreme Court says judges should restrain themselves to overstep and put the in that field of academician. That is the complete academic field and expert field. Now, my lord, being an officer of the court, always we have to search the remedy. What remedy remains? Being before a model selector, I formulate this in 4 manners. The first option, what option there? First option that we stick in our stand in respect of Madrasa Service Commission. That is, we will arrange 74 an examination, another examination for 74,000 candidates. That is one option. What they did. Another option might be that according to the division bench judgment, we will not hold examination. That is option B. Option C would be we will set aside everything and we will start it de novo. That would be the best option. Why? I open my submission with a word. In our country, no one have that right of employment. But equal opportunity in public employment, that's the fundamental right. In anyone's mind, if it is came, it might be error. It is 2 types. Either it is a malafide error, malafide mistake, or bona fide mistake. Whatsoever might be. The third option is the fruitful error. Now, my lord, I came to the argument which is prepared by a very esteemed senior, that is Anindya Mitra. He says, in that decision, we are not the party to the proceedings. So, that would be not a right thing. Cancel the whole proceeding. I put this question to myself, whether any right accrued. It is well settled, mere inclusion in the merit list or mere recommendation does not create any right in their favor. Until and unless you are in employment, that is state. So, now, my lord, the 4th point, that is regarding unsuccessful. Time and again, because there are whisper. How you assess me as an unsuccessful candidate? Because I succeed in the preliminary examination. Thereafter, I sat in written examination. Thereafter, you bring 300% erroneous decision.
You don't interact that.
So, my lord, my respectful submission in this score, my lord, the court must restrain themselves, must not overstep in the foot of academician. And my lord, my respectful submission is that do justice to everyone. And the fittest justice in this score would be giving opportunity to everyone and put everyone in the same footing. Now, the question is, if that court take that decision, is anyone's right will infringe? The answer is that no one right will infringe, because till date, no one right accrued. That's the reason. The best decision would be in this fact would be put, because we are now no one is in this process. In this process, no one is successful, no one is unsuccessful. Till date, everyone is in same footing. Now, my lord, proceed this selection process by putting everyone in the same footing. That's my respectful
The
submission.
best option would be to hold a fresh examination.
Yes, and same thing happened in the case of upper primary. In the before.
Sir, no side talk, please. It's very unparliamentary. It is within his right, and the court has asked him a question, he will reply. Don't make a reply.
My lord, in this score, I want to, although I will not cited it because it is reply. But in upper primary selection pieces in our
Sorry,
state,
Mr. Ahmed.
and another thing I just want to, in the year 2009, selection process, what happened, because my learned
Sir, I don't
friend,
require.
Malad,
I must
because
confine it.
I want to
No,
regarding
sir, I will not hear.
Assam
That's all,
matter.
that's all.
Just,
Mr. Ahmed, please come.
just Assam matter. I just want
No, 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 sir, I will not hear. Sir.
as my lord, I am extremely grateful, my lord, for patience.
As I have
What's your WPA number?
9578.
2024. Yes, sir.
Lad, three of my submission, as I have understood, lad, not replied by anybody. One is in the order of Justice Pratik Prakash Banerjee, they have given reason. They cannot supplement now. This first part, Rashid has recorded that. Second, the order challenging this notice. There was an interim order passed by Justice Amrita Sinha restraining them from conducting any further election test. Whatever they have taken is nullity because in violation.
That you have stated.
And third, nobody has challenged the result that was passed earlier. None of them who has now joined after participating based on the fresh.
Which result?
The first result in which I was declared qualified, written test, and they were not. That result was nobody has challenged. Now, after publication of fresh notice this year, after participating, they have come that we have accrued right. But they have accepted that result. Nobody has challenged.
That you have stated, sir.
Now, in reply, I have twofold of submission. One, this has come from their end, that's why, that there cannot be two tests. In the first phase, there was the different category of question papers, A, B, C. The questions were same. The series was different. Different series was there. Here also, different series was there. Question paper in this series, in this set, and the question paper of that set was different. Therefore, test is unequal. In any event, we have come before the REIT court. REIT court is not considering the decision, rather the decision-making process. This selection process cannot be never-ending process. If tomorrow they find after the interview that there was a lacuna in other process, whether they will return back and conduct again, then the process of selection will be never-ending. This can't be. In judicial review, court has to look into whether this decision is arbitrary or not by making it never-ending. That's all.
Anybody? Any more? Complete? Very good. Take down.
We are everyone extremely grateful because
My lord.
they said they are because of the corridor is there. They are satisfied. Really,
না না আমাদের তো দেব। Yes. Take down.